doesn't necessarily matter what the name is on the building. You're developing a relationship with someone that you know and trust. And that's the way I like to build my practice. I've been to clients' weddings. I've been to their birthday parties. Once you put your dispute into the hands of someone who has not lived and breathed it for the past 2, 3, 4 years like you have, you're rolling the dice on the way they're going to see your claims versus the other side's claims. So there is that unknown risk there. No matter how well prepared you are, the things just couldn't go your way. So that leads to a lot. And I've got some thoughts too about, your small business owner that only goes through this once in a lifetime, maximum 2 or 3 times in a lifetime, the kind of protections that they need to put into their contracts so that the project goes smoothly and that it costs them as little as possible.
All right. Yeah. Welcome to another episode of the Mind Your Own Business podcast. I'm here with extra special. I know most of the time they're special guests. Today we have an extra special guest because Phil Parham, star of Abraham Lincoln Vampire Killer
versus Zombies. Yeah.
Abraham Lincoln versus
Zombies. It was the mockumentary of the one that made a lot of money.
Yeah.
That's right.
Actual true story. You were an actor in Abraham Lincoln versus Zombies.
Yes. Yeah. I did a couple of things back in college before I knew what I wanted to do in life, and thought acting was the road I wanted to take, and had some decent kind of mid-sized successes with that. But then I also realized it's pretty hard to keep a woman interested in you if your prospects are, don't worry, baby, one day this is all gonna pay off. so I decided to go to law school.
So law school, easier to get a woman.
Yeah,
as an attorney.
A lot easier. Fortunately, I already had been dating my wife. We've been together 20 years now. And she, for some reason, saw something in me that was like, okay, maybe I should stick to it.
Nice.
And we kind of built this dream. Then she went to law school the 3 years after you and I went to law school. Yeah. So she was the first class to go all the way through the brand new building at Georgia State.
And what is she doing now?
She came out working for Guilmette Legal Aid, and then once we had our third child, it was it didn't make financial sense to have her working just to put the kids through daycare and school. So right now she is enjoying being a stay-at-home mom, and I got to tell you, I'm pretty happy with that too, because now I don't get calls to go pick up the kids out of work and things like that. She's doing a great job, and I think she'll eventually get back into the law practice somehow once the kids get to a stage where they don't need the constant. They're in the Darwin phase of life right now, where they're trying to take themselves off the planet at every turn by doing stupid stuff, and she's just kind of guiding them through that.
Awesome. Well, yeah, my wife's a stay-at-home mom too, and it's awesome. Yeah. Well, as you just alluded to, we went to law school together.
We did.
Graduated over 10 years ago now. Can't believe it.
Yep.
What have you been doing since?
Well, I came out of law school and went into the quote-unquote big law. And found big law. You got the big shops that the two firms in big law that I worked for had a southeastern presence, and they probably had between 300 to 500 attorneys in the law firm. And there's kind of where I learned the practice of construction law, and was fortunate enough to have a lot of my mentors along that journey be highly renowned construction attorneys, extremely good litigators, and was able to learn the practice of construction litigation under some of the best out there.
Cool. Let me stop you there. Before you get into construction law too deep, I want to What was your experience in big law? Because, you know, I've never practiced in a big law firm or anything like that. And we went through law school, and that was sort of like the quote unquote dream job.
You're right.
But you also hear horror stories.
Yeah, that's what everybody tells you. They're like, man, if you can get a job in big law, you've got it made.
And I've got an intern behind the camera who I'm trying to convince not to go to law school. So can you tell us what the dream job is actually like?
Sure.
How the sausage is made?
Yeah. So the dream job is you get paid very good money, and they expect a full devotion devotion to the job, which is not an unfair expectation, right? I mean, they're paying you very good money, but they also need to generate a lot of money off of you as well. So the hours are a lot. There are many. You have to bill 1,900 to 2,000 to 2,200 billable hours a year. And keeping in mind, for the people who don't know, a billable hour, you're actually generating work for a client. So you might be spending 55, 60 hours a week at the office to generate 40 plus billable hours of work.
It's not like every minute you're at your computer, you're billing.
That's exactly right. Yeah, it's not a punch in, punch out system.
Yeah.
So it is great because you have extremely good litigators there, or extremely good transactional attorneys at Big Law. You get to deal with some of the really sexy cases, some of the really big money, very complicated cases, and you learn how to be a very good attorney and a detail-oriented attorney there. However, it is not as conducive of an environment to having a family and things like that. So eventually you're going to have conflicting priorities that you have to be able to manage.
Yeah.
And that came to me last year when, after continuing to spend nights at some of the firms and
sleeping at your desk,
sleeping at the desk type of thing, or pulling all-nighters. And I got, you and I, we kind of went to law school a little bit later in life than the typical, what we call K through JD career path. So it became, I had at that time a 5-year-old and a 4-year-old and a 1-year-old. And I realized I probably have only 6 or 7 years left before, to shape what my kids are going to say to me about me over my grave. Yeah. And it can either be, Dad provided us everything we ever wanted, but he was never home. Or it could be, Dad was there a lot and he was a constant presence in life. And I just kind of chose the latter. I talked to a good friend of ours, a mutual friend of ours, Tim Guilmette, who has his own law firm. And he convinced me to come over and carry the construction practice there and lead building a construction practice group at his firm. So now I work for Guilmette Henderson, and they are in Midtown, and they do business law. They do a lot of fraud investigation work. They've got some extremely talented litigators there. One of them named Brian Henderson, who is Tim Guilmette's partner, and he came from a prosecutorial background. So he's tried hundreds of cases, and he's probably one of the best litigators I've ever gotten to see in action.
Wow.
So learning a lot there with them, and then their expertises and their practices kind of complement mine. Tim, of course, had a big real estate background, a lot of residential construction background. Mine's commercial construction background, and so we've been able to kind of set this thing on a path to lift off.
Cool. Did you bring any clients with you, or did you have to start from scratch building your book?
I had a number of clients that ended up coming with me over to Guilmette Henderson. Once you've got, I think, the chops to be able to swim in the big waters and they get to see that, then they are going to come with you. And I tell a lot of people this, particularly developing their own business or own practices in law, is that, it doesn't necessarily matter what the name is on the building. You're developing a relationship with someone that you know and trust. And that's the way I like to build my practice. I've been to clients' weddings. I've been to their birthday parties. They get to know you. They get to trust you. And you become more of that counselor role than just this is my attorney who I call when I'm in trouble.
Gotcha. So what's been the biggest difference between Big Law and being at Guilmette Henderson?
There's been a huge shift in learning what it takes to manage a team, I think. Coming up through Big Law, you get to, you're told what you need to do, when you need to do it, when your deadlines are. You've usually got your managing partners who are the client relationship people who've got the overall view of the case. And of course, you're part of a team, so you're in on planning this out. But transitioning from being one cog in the machine to being the person who has to run the cases and know what the next steps are and develop the strategy, having confidence in the strategy that you develop, and then execution is a pretty big learning curve.
Cool. So you talked about construction law.
Yes.
And is that most of your practice, or is that all
That's
of your
all
practice?
my practice. Yep.
Okay.
Yep. I only do construction law, and it's about, I'd say 30% of my practice is negotiating contracts, writing contracts for clients, handling a lot of the transactional work that goes into the pre-construction or the development of the contractual relationships during the construction process, managing issues as they come up on construction sites, looking back at the contract. Okay, we've run into a bit of delay here. What are our rights under the contract? Can we accelerate work for our subcontractors? If I'm representing a subcontractor, do they have the right to accelerate work, require nights, weekends, additional manpower? And if so, what are the consequences of that? So you're managing a lot of the construction as it's taking place. It's about 30% of my practice. The other 70% of my practice is litigation. Once a dispute has developed, we're taking it from the very beginning stages of a dispute. If you've got a good client who recognizes there's a lot of risk coming down the road, they're going to get you involved very, very early, because at that point, you're able to manage the dispute and kind of tailor the path that it's going to take, rather than being thrown in mid-dispute or end of the dispute when a lot of the documents are already written, a lot of the dispute is already developed, and you have much less control over the outcome at that point. So,
and for those that don't know, litigation means we're in court. There's a dispute,
right?
Somebody filed a lawsuit, and we're going to court,
right?
That don't necessarily know the legal side of the construction industry.
That's right. So whenever you got a dispute, you're going to have some way of resolving that. If you're unable to handle it through mediation or diplomatic communications between the interested parties and the powers that be and the decision makers there, you're going to wind up in court, or you're going to wind up in arbitration. Yeah. And a lot of my practice is in arbitration versus court, which are two totally different worlds. You deal a lot with court. The rules of evidence apply. It's a lot of managing this very well set out process that is statutory in nature or governed through the rules of court. In arbitration, it is outside of the court system. Typically, you don't have a judge who is, or it's certainly not an active judge who is arbitrating your case. You may have retired judges. You may have attorneys. Sometimes you may even have non-legal adjudicators that don't non-legal. They don't have a legal background. They could be engineers, they could be contractors, they could be architects as their background. So managing that process, selecting your arbitrator is very, very important as you go through this process to get someone who understands the dispute and the issues.
What's the determining factor whether a case goes into litigation in the traditional sense or arbitration? Is it contractual?
It is contractual. So you got a number of form contracts that are used in commercial construction. You've got the AIA contracts, you've got the consensus doc contracts, which I prefer consensus docs. But in all of these contracts, it's going to anticipate the existence of a dispute somewhere along the way. And once a dispute comes up, you've got to turn to the contracts. What did the parties agree to prior to beginning their work on the construction project, on how they're going to resolve a dispute as it comes in? And I tell business owners, I tell contractors, I tell subcontractors, if you're in the business long enough, you're going to be in litigation at some point, or at the very least, if you're lucky, just the threat of litigation that you're able to resolve outside of it.
Right.
Just because, I mean, these are really complicated projects. You've got designers, you've got architects, you've got banks that are in there doing the construction loan, you've got your general contractor. The general contractor subcontracts all of its work down to subcontractors. The subcontractors may have subcontractors. They may have material suppliers, vendors, laborers, trucking companies that come in and deliver product. All of these relationships are managed by contracts. And So you've got to view the contract that you are entering into in relation to all the other contracts that are actively governing the relationships of the parties who are working.
On a big project, it can get complicated.
Extremely. Yep. I have been fortunate enough to be involved in some of the biggest lawsuits in some of the southern states out there. And the biggest one I've ever been involved with probably had 40 parties to it. And this was in court. 40 parties into it. And you imagine each party.
How the case caption fit on did it fit on one page? Or
we use the term et al. But yeah, so but no, the case caption was about 2 pages long.
Nice.
On that. So, but a very, very interesting case.
Can you tell us anything about what the dispute was? Sure.
So the dispute was over a large multi-use development down in Miami, Florida. And it was so big, it actually had 2 general contractors. One general contractor was the one who built all of the sub-ground structures, like the parking garages underneath the vertical structure that comes up. Gotcha. And so there were issues of design and issues of execution over all of the subterranean stuff. And then there were issues with design and execution of all the above ground stuff. So it was extremely complicated, lots of overlapping work, a number of overlapping subcontractors who worked on both the below ground and above ground structures.
So what happened did the whole thing collapse?
No, nothing like that. Nor was there really even a threat of anything like that happen. Gotcha. So the part that I was on a team developing the arguments for and the defenses for, there were allegations that the concrete was defective in some of the below ground parking spaces. You had what's called spalling in a lot of areas, which is where you got moisture getting trapped in some of the structures, like the rebar. That moisture can cause the rebar to corrode, and at that point, it causes the concrete to start sloughing off or flaking off, and that's called concrete spalling. I'm dealing with another case right now that has concrete spalling issues out of Florida. Eventually, like most big lawsuits, that ended up settling before ever going to trial. Now, it settled on the eve of trial, but eventually the parties look and they have to assess what kind of risks are involved and how that'll affect the company. And once you put your dispute into the hands of someone who has not lived and breathed it for the past 2, 3, 4 years like you have, you're rolling the dice on the way they're going to see your claims versus the other side's claims. So there is that unknown risk there. No matter how well prepared you are, the things just couldn't go your way. So that leads to a lot of dispute resolution through mediation or settlement agreements prior to going to trial.
Yeah. So in my industry, not a ton of cases go to trial in the personal injury world. It's a very small percentage. And I did take a contract case to trial one time years ago, my first jury trial, and the judge basically told us, both the parties, like, what are we doing here? This is a contract case.
Yeah.
So is it even more rare for contract cases, in your opinion, to go to trial?
I think it is more rare in... I don't know that it's more rare for a contract case to go to trial. The way I look at it is litigation is like a game of poker. Right. And you've played poker around the kitchen table. You may have played it in casinos or something, but you've got a table of 10 people, right? And all of them are holding cards that the other person doesn't know what's in them. They get clues as to how you bet and what your decisions are along the progression of the hand. People are putting in large bets, representing they have more than they do. People are putting in large bets, hoping to maximize on what they do actually have. And at a certain point, everyone is trying to assess the strength of their hand as to the strength of everyone else's hand. Yeah. And typically, a hand of poker doesn't go down to the showdown where everyone turns up their cards. Someone has made a decision along the way that it's better for me to get out, or it's better for me to put in a big bluff and hope the other person gets out based on their own risk assessment, and the hand is settled before you ever go to a showdown. Well, it's the same thing in most disputes, right? You get through the complaint. You've got a lot of kind of pre-discovery motion practice. Then you go into discovery. You get to see the other side's documents. They get to see your documents. Then you go into depositions. And at each one of these key phases of the litigation process, the decision makers are having to reassess the value of their claim or the value of their defenses. And at a certain point during most disputes, someone will say, it's a lot cheaper for me to accept less than what I think I'm owed, or to pay more than I think I'm liable for, in order to avoid the consequences of that final showdown, where one person is going to look at all the cards that have been played on the table and say, you win and you lose.
Yeah. Well, that's a good way to put it.
Yeah.
I think it's pretty accurate for people that have never been through the litigation process also.
That's exactly right. And a good attorney is one, in my opinion, who looks for off-ramps during the litigation process.
Because litigation is expensive.
Extremely.
And risky. Because you don't know what's going to happen. So,
that's exactly right.
Okay. So a good attorney that tries to help you avoid it, or once you're in there, how do you get out with the least amount of pain possible, right?
That's right. Yeah. You don't want an attorney who's a yes man, who just buys into your story. Your story may be right and it may be accurate, but you want an attorney who can sit there and tell you the real weaknesses in your case or the real strengths of the other side's case, and advise you. And ultimately, it's the client's decision, but who can advise you, hey, here's an off-ramp. Let's get you back to the business of generating money for your business and putting food on your employees' tables, rather than spending money to fight this out. And here are the reasons I think you should do that. And here are the price points at which I think that becomes worth it. So if you've got an attorney, they've got to play the bad cop for you too. Yeah. You know, the worst thing that, in my opinion, that can happen to a client is the attorney just agrees with them. You've got a great case. You're going to win this. You're going, we're going to get you everything that you asked for. And we're going to get them to pay your attorney's fees and all the costs. And then you go into trial, or you go into litigation, and you've got that hard phone call to make at the end of the day when it didn't go their way. So
yeah, but you still bill $500 an hour, right?
Right. But that's not the service that we are supposed to be offering.
Right.
You know what I mean?
Yes.
You're supposed to help people through some of the most difficult times, particularly for small business owners. It's a little more palatable for a $1 billion a year company to lose a case that's $1 million, right? Than it is for a small business owner who might generate $3 million in revenue.
That could put them out of business. Right?
It could put them out of business. That's exactly right. It could change the entire trajectory of the company. So you really want to look for an attorney who can advise you as to both the good and the bad, and who knows the law, has experience litigating claims, and can tell you from their own experience what your options are and what the percentage of success is for each of those options.
Yeah. So litigation, expensive, time-consuming,
extremely
stressful,
right,
risky.
That's right.
So how do you advise your clients as far as getting their contracts together,
right,
doing stuff on the front end when the deal is being negotiated to avoid those sort of problems down the road?
Right. It's a little Sun Tzu-ish, where you're like, okay, the battle is won before you ever step foot on the battlefield type of mentality. You've got relationships that are all governed by contracts, right? So a small business owner may only go through construction once in their entire lifespan of their career. It may do it a couple of times. It all depends on what kind of business. But you've got small business owners who are looking to build a new building. They're looking to renovate a long-term leased building in order to get it built out to the needs of their business. And these are major expenses. Everyone, I don't know a single case where everyone comes together and they say, let's build this building and we're going to disagree the entire way through. You know what I mean? It starts with a set of drawings and a set of plans and a budget and a schedule on how you're going to execute the project in order to take everything from on paper to this wonderful and beautiful building, right? Yeah. But because it's complicated, which we've kind of already discussed all the moving players, disputes will arise. So you've got to make sure that a mechanism for resolving those disputes is going to be written down and agreed to by the parties before the dispute ever happens. And it's not necessarily even limited to disputes, right? There are milestones with construction projects that you have to achieve. There are situations that come up where, hey, we couldn't get the exact brand of pipes that the contract requires to be installed at the project. We've got to look for an alternative, a substitute product to put in here, and approving those. So how are you going to handle all these situations? And I tell my clients, my good long-term clients, spend a little bit of money up front, right? Have an attorney at the initial phases of looking for a contractor, of looking for an architect or designer. If those two are separate entities, there's several ways to build a project. But what you're typically going to see is you've got an architect and a designer who your owner is going to contract with. That architect, the engineer, the design team is going to produce a set of plans, a set of specifications, right? And then you're going to go out and you're going to find a contractor who's going to build the project based on those plans and specifications. So having an attorney and to negotiate the finer points of those contracts before you ever break ground, before you ever spend any of the money from either your war chest that you've been able to build or your bank loan, having a plan of execution and having your rights and remedies built in and agreed to before this process can save you tremendous money on the back end when a dispute arises. I have been in cases, and I'm thinking of one in particular, but I have been in a case where had the client engaged me to review the contract, to negotiate the contract, they may have spent $5,000, $6,000 doing this. Had they done that, we could have put in these clauses that would govern the dispute that eventually happened. Instead, because they did not get the legal oversight going into the project, a dispute arose on the project, and they ended up spending $500,000, $600,000, $700,000 in attorney's fees and ultimately settlement proceeds. So it really is worth that kind of what do they call it? A pound to prevent, an ounce of prevention is worth a pound to cure type of thing. So I think having the attorney in at the beginning is really, really important.
Yeah.
So, and I've got some thoughts too about, your small business owner that only goes through this once in a lifetime, maximum 2 or 3 times in a lifetime, the kind of protections that they need to put into their contracts so that the project goes smoothly and that it costs them as little as possible.
Let's talk about that. So you're talking about when a small business owner wants to build out a building for, their store or the restaurant, or is that what you're talking about?
Yeah, exactly.
Okay.
Exactly.
So what's the first thing they need to do when they start thinking about this? Do they hire an attorney first? Do they look for the architect first?
Yeah. Right.
If they're a small business owner, they've never been through this before, where do they start?
So there's a couple of things. Number one, I heard a very, very wise lady who started a very reputable general contractor give a talk one time, and she said the first thing you need when you start a business is you need a good CPA and you need a good attorney. Right? It's very much the same way, at least as the attorney, when you're thinking about building a new restaurant or building a new office building. Right? You need to engage an attorney who is a construction law specialist from the get-go to help you present your owner contracts, because that's the way a lot of these work. Is if you don't have a contract to present to the general contractor, they're going to present one to you. Does that make sense?
Yeah.
And these general contractors, because they're in this business of constructing, they've got attorneys who have already likely drafted their contracts when an owner doesn't have one to present to them.
So it sort of favors that side.
Of course it does, right? When you hire me to build out your form subcontract or your form owner contract, I'm going to put in the maximum protections possible for you because that's my job, right? And then if you push back, we can negotiate. We can find out why you want certain clauses changes and understand that. My view of a construction contract, a fair construction contract, right, a good one, is the one that allocates the risk to the entity or person who has the most control over that event, over that risk.
Interesting.
Right? So
it allocates the most risk to the party that has the most control.
That's right. That's right. Yeah. And you wouldn't accept a contract clause that made you liable for someone else's part of the job, right? Because you don't have control over the way that part of the job is executed. But if you can look and understand the different roles of the people on the project and create a contract that allocates the risk properly and fairly to the entity who has the most control over it, you're going to run into a lot fewer problems in the long run. So a couple of things that I think a small business owner should look out for, right? To begin with, I think you want a good indemnification clause. That's a big contentious provision in every contract.
And what does that mean, indemnification clause?
So an indemnification clause is an allocation of who is going to pay for damages that are caused on the project if they arise. So let's say that a worker of one of the subcontractors is on scaffolding and doesn't have his safety harness on or something and falls and gets injured, right? That, coming from the personal injury world, that worker has a lot of options on who to sue, right? But one of the parties that it can sue is the business owner who owns the land, right? Mm-hmm. And if that worker sues the business owner, well, the business owner wasn't the one that necessarily hired that worker. He didn't vet that worker. That's the subcontractor who employs them, right? But now you've got a subcontractor's employee suing the business owner for injuries that happened on the project. You want that subcontractor to say, look, if I've been negligent in the management of my workers, they didn't follow the safety protocols that they were supposed to, and one of my workers gets injured and they sue you, I'm going to defend you. Right? I'm going to indemnify you. That means if you were found liable for medical bills from that, rather than you as the business owner paying for those medical bills, rather than your insurer paying for those medical bills, now you want the subcontractor to do that because he was the one who was in control or had the most control of that risky situation that led to the injury. So things like that goes to personal injury on a construction site. It goes to property damage on a construction site, right? Let's say a crane is installing some beams on some upper levels, right? And something happens with that crane and the beam swings and it damages the neighboring building, right? Now you've got a lawsuit on your hands. You want the person who is in control of that beam and in control of the crane to be the one who is liable to defend the business owner for that damage. Otherwise, you and your insurance company have got a major expense on your hand with an unknown outcome.
Yeah.
So that's an indemnification clause.
And that's something that a lot of business owners may not think, I'm going to get sued for this.
That's right.
Some subcontractor hired some guy who was drunk and swung this beam into somebody else's building.
That's right. Yeah, no, that could very well be the case. There's also, putting in the scope of work, and this goes to a lot of time overlaps and delays and things like this can happen, or arguments about whether the contract price included installing the underground utilities, right? Mm-hmm. So every construction project, it's extremely complicated. You've got, land clearing and grading if that's needed. You've got installation of the underground utilities. You've got installation of electrical. You've got installation of plumbing and HVAC and all the mechanical components. You've got the pouring of the concrete, the framing, sometimes demolition of a pre-existing building. All of these things, right, have to be done to have your ultimate project be a success on time, on budget, okay? So one of the things that you want to make sure is in your owner contract is having a very detailed and very, very clear scope of work. All right, I'm going to pay you, Mr. Contractor, $1 million to do this project. What does that $1 million get me, right? Well, we're going to look into the contract and see what that $1 million gets you. Otherwise, if you don't have a very detailed scope of work that is set forth in your contract, you could get to situations, and many times throughout the project, where the general contractor looks at you and say, no, the price doesn't include this extra work that we just found out about. Let's say they hit, let's say they're doing grading work, right? And they hit rock 3 feet down that they did not know was there. Yeah. Does the price that you've negotiated and put into the contract include the additional labor and additional time and additional manpower that's going to take to blast that rock out and remove it, or does it not? All of that's going to go into the scope of work and into your contract clauses. These are things you have to think about. The other one, what happens if, and one of the most important things, particularly for these small business owners, is negotiating payment terms, right? It's, I think, an understandable viewpoint to go into a large construction project saying, I've hired a really good general contractor to do this, and I'm just going to trust anything that they say along the way because they're managing. And you should be able to, right? You should be able to trust your general contractor. And the very reputable general contractors out there, you can absolutely trust them to do everything right? Mm-hmm. But having some safeguards in place for these different milestones is key. And a lot of that comes into the terms by which you're going to pay out the contract to the general contractor as they hit milestones. So, for example, it is completely reasonable for a contractor to ask for mobilization fees. That's the fees that it takes them to get their equipment aside and to start working on your project. Okay. And maybe even a percentage of the contract up front, say 10%. We're going to start work. We're going to do 10% plus mobilization. Then we're going to get to work on your project. But they've got to accomplish certain milestones before they're entitled to payment along the way. This could be a year-long project. You're not going to pay for a year-long project all up front and just trust them now that they have the money to get it gone, although you should be able to do that. But you're going to have different checkpoints along the way, periodic payments. What are you going to show me when you submit your periodic payment application that assures me that you have done the work that you said you were going to do, that you were entitled to the payment you were asking for, right? And that you have protected me by paying all of your subcontractors and vendors and suppliers along the way. What are those documents going to look like that you are going to have to turn in with your payment application to prove to me that you're on track and on time and that there's nothing wrong with the project right now, and therefore I can confidently release it? One of the things you can negotiate into one of these is holding retainage, right? Okay, you're going to do $100,000 of work in the month of May. Well, under the contract, the owner may want to have the right to withhold 10% of all of the payment applications until the very end of the project. So at the very end of the project, if there's a punch list, if there's stuff that still needs to be done, there's motivation for the contractor to get back out there and finish the job. And what's that motivation? You're holding 10% of my money.
Yeah. You mentioned, I think you said, what are you going to show me to protect me that, the general contractor has paid the subs and the material suppliers? Right. What are some risks there of the general contractor potentially not paying the subcontractors and material men?
Right. So a lot of my work deals with what's called lien law, right? Okay. So every state has its own statutes that will govern the circumstances under which someone who works on a project or provides material to a project or rents equipment to be used on a project, these statutes govern when they can actually secure their right to payment through the project itself. And these are called mechanics liens or materialman's liens, right? So let's say that general contractor taking care of the whole project, right? And a vendor who is supplying a bunch of corrugated pipe to the project, say they $50,000 worth of corrugated pipe is coming. If the general contractor does not pay the vendor for the corrugated pipe, worth $50,000 in this case, there are certain times and under certain conditions where that vendor can put a lien on the property. Taken to its ultimate conclusion, a lien can be foreclosed on. And so that vendor, that materialman, can actually foreclose on the project itself, sell it out on the courthouse steps to the highest bidder to recoup their $50,000. That's a hard pill to swallow when you're the owner. You've paid the general contractor, and people down the line have not been paid. Now, not only have you expended $50,000 that you thought was going to pay for materials, but the owner, in order to get that lien off the property, has to pay an additional $50,000 that should have gone there, and that is a huge, huge risk. So, kind of really quickly looking in the rearview mirror as to the contracts, right, and what provisions are in there. One of the most important things is to have the ability to contact the subcontractors and the vendors on the project. Having the ability to ask the contractor, I need you to identify each of the people that supplied labor and materials to the project so that I can contact them and double check to make sure they're being paid, right? Now, there are mechanisms in lien law that can force this to happen. There are also, I like to have that in the contract as well, right? What do you do when you find out they haven't been paid? What are your options? Well, one of the things that I like to ensure is in a contract is the ability to issue joint checks to both the contractor and the subcontractor, right? So if you get a call from the subcontractor grading company, say, hey, I'm sure you're on top of it, but my general is about 2 months behind on payment applications and paying me. You look down at your record books like, well, I'm not 2 months behind, so why are they 2 months behind? Now you can have that talk with the contractor. And you can say, look, I'm going to issue your check jointly payable to the subcontractor who says you're behind on payment. That means you can't cash the check without their signature on it. And you'll need to work out a way to get them paid through this check.
Nice.
So that's a great way to protect yourself. Another great way to protect yourself is requiring partial lien waivers with periodic payments, right? So they're several months away from being done with the project, but they're turning in their June payment application for all the work they've done in June. Before the small business owner it releases that payment for June, I highly recommend that the small business owner gets a waiver of any rights to put a lien on the property in exchange for that amount of money. So here's the way that works out in practice, Jerry, is the general contractor has applied for $100,000 worth of work that they performed. With that payment application, pardon me, I'm going to take this Parisi law firm swag with.
You like it?
It's very good. I'm going to take one of these home with me. I'll have to pay you for it, I'm sure, though. So what the general contractor is going to do with this $100,000 payment application is I'm going to require as a small business owner for him to write on a piece of paper, a form that essentially says, in exchange for payment of the $100,000 that I'm due for work on this project, I'm going to fully and irrevocably release my rights to lien the property for that $100,000 once I've received the $100,000 in payment, right? Now, this is where you need a good construction attorney on your side who is familiar with the lien statutes in your state. I consider myself a lien law specialist. I get hired by a lot of people just to litigate lien work. We were recently able to get on across 4 projects in Georgia, and they were all these big solar farms, where they go in and they put up solar panels on these big acreage. The contractor had put a total of $52 million in liens across these 4 projects. But because we knew lien law and we knew that these lien statutes are strictly construed in favor of the owner, if you miss a single step, those liens are not good. Right. And we were able to successfully remove $52 million in liens from these 4 projects because we knew that law and they had not followed the steps necessary to secure their lien rights. Well, one of those steps is this partial lien waiver, right? And Georgia requires a very strict word-for-word form in order for these things to be enforceable. So you as a small business owner need to make sure that your lien waivers are on the correct form for them to be enforceable, right? So it's things like that that you need to protect yourself from.
Geez, so the liens and the lien waivers strictly construed, that means if everything is not the way the statute says it's supposed to be, it's not effective.
That's exactly right.
$52 million in liens you were able to wipe away because you found that they didn't comply. How minor was the discrepancy in that case?
Some of them were, because he had a lot of liens, right? This wasn't just one lien. It was 4 liens across several projects. There were a combination of things that the attorney on the other side had missed, or that the developer. They did. They had an attorney who did some of it. An attorney can only work with what you got at the time that you hire them too. So you can't blame the attorney necessarily for everything on this. It's one of those situations where, going back to what we said before, get an attorney involved early and they can guide the paths to make sure you secure your rights. Well, in this case, the developer was, I can't remember where it's Arkansas, Arizona, some other state, and they were doing work in Georgia, and they didn't know Georgia lien law, so they missed a lot of deadlines. For instance, when you file when you sign one of those partial lien waivers, if you are not paid in full for that amount stated in the lien waiver, then you have 90 days to file what is called an affidavit of non-payment in the land records. And it's just what it sounds like. It is, hey, I swear that on this date, I signed a lien waiver in this amount. To date, I have not been paid for that, and I'm letting the world know that I'm securing my rights to file a lien for this amount. You have to do that with every lien waiver that you sign on the course of a project. So a good contractor is going to be keeping track of when they signed a lien waiver on this project, when the payment was due, and 60 days in, my general contractors or clients are calling me to fill out these lien waivers to make sure they don't miss the deadline. Back to your question of strictly construed. This is one of the few areas of the law where if you miss a deadline, it's over, done. Yeah. There is no reviving your right.
There's no whoopsie, judge. Sorry, I made a mistake.
No,
my attorney made a mistake.
Yeah, or my paralegal was sick that day,
or the mail didn't run.
Exactly. Yeah, there are no excuses. If you missed it, you missed it. So, that's one of the pitfalls there. But it works out favorably for the owner because there are a lot of things that the owner can do to ensure that all of the people are meeting their notice requirements. Going back to the lien law portion, one of the things that you as a small business owner need to require of your contractors that they file a notice of commencement in the land records, right? And that under Georgia law must be filed within 15 days of first stepping foot on that project. And it has
15 days.
15 days, yeah. So from the moment you break ground or you get out there and you start cutting down a tree or anything like that, what you're going to have to do, what you need to do is file a notice of commencement in the land records. And that notice of commencement is filed in the county where the project is located, and it sets forth, among other things, who the general contractor is and their contact information, who the owner is and their contact information, who the work is being ordered by, because sometimes the person who owns the building may not be the person who's ordering the work. It could be a tenant, who a construction lender is on the project, if any. So you've got all of this information that is filed there in the land records. And what does that do? That tells all of the people who are working on the project, here's who's involved. And if you have a right to claim a lien on the property, here are the parties that you need to include. What does that do to protect an owner? Well, number one, if there is a notice of commencement on the project, it triggers a lot of responsibilities for your downstream subcontractors, vendors, suppliers, material men. They then, if there's a notice of commencement, have to come up and tell the owner and the general contractor, you don't know me. You don't have a contract with me. But I've been hired by someone you have a contract with to provide concrete cutting services, right? I anticipate that I'm going to be doing about $80,000 worth of concrete services on your project. And if I'm not paid, I've got the right to file a lien, just a heads up, right? If you file that notice of commencement and that concrete cutting sub did not give you that notice to contractor, they've automatically waived their lien rights there. So
they cannot file a lien if they didn't send that notice to contractor.
That's exactly right. It's a little more nuanced than that, because that particular requirement is retroactive for 30 days. So say they've been working on a project for 90 days, right? But they don't send you that notice to contractor until day 60. They've essentially waived the first 30 days worth of liens, but from that 60th day, that's going to look retroactively to the 30th day and forward. So that they could have missed a big chunk of their lien rights. So there's a lot of things there that you've got to be cognizant of. And there are a lot of internal protections that these business owners can take to ensure that they know who's working on the project, how much is owed, are they being paid, and am I at risk for liens?
Yeah. What do you think is the number one thing besides hiring an attorney that a property owner can do, or a business owner can do, to protect themselves from these issues?
Research the people who are going to be building the building, right? So there's a lot of resources out there. If it is a project that is going to require someone who is licensed to do work, right? So let's say they're building an office building, right? Well, under Georgia law, if you're going to build an office building, you're going to have a general contractor's license to do it. So you can go to the Georgia Secretary of State and look up to make sure that the 3 general contractors that you are looking to hire are going to be able to do that under their license in the state of Georgia, right? The last thing you want, there's a lot of people out there, and I love the construction industry. Like, it is near and dear to my heart. Most 99.5% of people who are in the construction business are all hardworking, great people. But like every business, law, medicine, anything else, you've got bad actors out there. You got a lot of people out there who are There are a number of people who are obtaining jobs that require to have a license, and they don't have the license. They may represent that they have the license, but you are not getting your work done by a licensed contractor. So making sure they've got all of the paperwork and the licenses that are required to do the work they're going to do it.
Where can you check if they're licensed correctly?
Yeah, there's on Georgia Secretary of State, or you can just Google, Georgia General Contractor License. Look up I believe it's the licensing board has a search feature where you can search by entity and type of license.
Gotcha.
To verify that number one, they have the license, that number two, it's active. So those are things. Do your homework. Talk to people who have used this contractor before to build a building or to remodel a building. Did you have any problems on? Were you over or under in the time or the budget that you expected or contracted for? Doing your due diligence. If you've got an attorney, they can also search all of the land records in Georgia by this general contractor's name. They can see, has there ever been a judgment against this contractor out there and then they can look into the underlying lawsuit. Like, what were the allegations? Was it a failure to perform work? Was it delays on the project? Why did they have a judgment against them? And it gives you an idea. And look, plenty of people get judgments against them and they didn't, this could be just a one-time thing where, man.
Doesn't mean they're bad.
Doesn't mean, no, absolutely not.
Fulfill their responsibilities on your job.
Yeah, absolutely.
But if they've got maybe 10 judgments against them,
you might want to look into that a little bit more. Yeah, that's exactly right. What projects have they worked on the past, right? Have liens been filed against that project property in the past? Because that tells me that the general contractor hasn't been paying their subcontractors, or the subcontractors haven't been paying their material men. And there's a distinct difference between the two, right? Who was responsible? Who let the ball drop? Who caused this headache for the owner? You want to, a lot of people are really terrified and intimidated by the construction process because you don't know what you don't know.
Yeah.
You know what I mean? But there are ways to research and do your due diligence to give you the best shot at having a successful construction project.
What crazy stories have you seen in the litigation, in the, deals gone wrong?
Yeah.
What's the craziest thing you've seen?
Well, craziest thing I've seen. I'll tell you a really sad story, but it does get crazy and it does get interesting. Back in September, I was called by an owner of a project who was building out a shop to do business. Diesel mechanic repair was the business, right? And they were building it actually right here in Jefferson.
Oh, cool.
And they purchased this property, land, family, hardworking family, first generation immigrants come in, and they're going to open up this business. And so they pour their life savings. They save 20, 30 years worth of assets to build this building and start this dream of small business ownership. So they interview a number of grading subcontractors and a number of building or contractors, right? And they're going to do this in two phases. They're going to, number one, have one grading company do their grading work for the land. And then they're going to have another contractor who's going to build the building itself. So they get in and they hire this grading company. And, it seems like work is progressing. But then I get a call and he says, Phil, well, here's the story. I've paid this grading contractor all $600,000 of my contract price, right? $600,000 to do the work. Along the way, the grading contractor presented me with about $200,000 in change orders. Immediately, red flags are going off, because there's no reason that a contract should increase by 30%. Something's going on. And I paid them all of that, 100% of the funds. And now I've got 4 liens on my property. You know what I mean? That is about $200,000, $230-something thousand in liens on my property. How can I get these off? So I go in. The first thing I do is obviously check the liens, make sure they're valid. 3 of them are valid. 1 is not. And then I've got to give the contract or the business owner the bad news, which is they can foreclose on your property, right? And we've got to get these liens off, but there's no way that you're going to get the contractor who abandoned the project after it was found out he wasn't paying his subcontractors to pay them out of the money you've already paid. You were going to be liable, in other words, for paying these liens off. Now, we were able to negotiate some of them and get them done. But what does a lien do? It puts, when the date someone files a lien, anyone else who comes in with a property interest after that date, the lien has priority over their property interest. So the business owner is now trying to get construction funds, an additional bank loan to finish the project out, right? Well, the bank is not lending them money because they've got liens in front of them. And the lien claimants, these subcontractors, are not willing to subordinate the liens to the bank so that he can get the money out of that loan to pay off the liens. You're in this catch-22 situation. And now he says, look, and this grading contractor has been a horrible actor. What do we do? Can we sue them? Well, I start looking at the judgments, and this grading contractor has at least 7 judgments against them. And I start contacting the people who've gotten these judgments. And I start contacting the people who have filed liens on other projects when they were working under this grading contractor. And all of them are telling me, we just weren't paid. We weren't paid. They just took. Look, if it weren't illegal, it'd be a great business. Like, what's your profit margin when you don't have to pay for anyone for their work on the product? It's like 100%, right? Unfortunately, it is illegal. So I've got to tell the client, the business owner, we can sue them, but it doesn't do you any good because you're not going to collect on the judgment.
So all those other people, those other 7 judgment holders, they weren't able to collect.
They aren't able to collect. I called the attorneys for a lot of them, and they're like, yeah, we tried to get a collection. We got $500 from a bank account that was closed down, and they owe us $130,000. So essentially you tell them, hey, they've really messed you up here. And I go talk to Brian Henderson, the guy who I said is in a prosecutorial background, right? And one of the best litigators. And he points out to me, and this is what I love about this mid-firm law, we're playing in new waters that I wasn't playing in big law, right? I'm learning new creative strategies. And he points out to a statute that says, no, the failure to pay a subcontractor on a construction project is actually a felony in Georgia. It is punishable by between 1 and 5 years in prison. And there's another great statute in Georgia that's been around almost as long as Georgia has been a state. And that is that anyone who witnesses a crime can go and apply to the magistrate, or they don't even have to be the victim. If you know of a crime, you can apply to the magistrate court of the county where the crime occurred and present your evidence and say, I believe we've got probable cause here for the judge to issue an arrest warrant, right?
Nice.
And so what we do is I tell my client, I said, look, let's see if the county will go after them criminally, and we're going to set aside our right to go after them civilly for a bit, right? And we're going to go after and say, hey, we believe a crime's been committed. They stole funds. They didn't pay their subcontractor. They didn't finish the project, and they've harmed us with all of these liens. So we apply to the magistrate court here of Jackson County, and they hold a hearing there. And of course, the owners of the grading contractor, we get a lot of calls from their attorney. This is a civil matter, and you're using the criminal system. And we have to explain to them, well, just like, a lot of things have a civil element to them, and they have a criminal element to them.
Yeah.
This is one of them. O.J. Simpson found not guilty of murder, but found absolutely liable for the wrongful deaths. So there's two worlds that are operating kind of simultaneously here, and we get up and we explain to the magistrate judge exactly what's going on. And at the end of the day, these two grading contractor owners, they walk in confident, knowing that this is a civil world. This is absolute BS. And at the end of the hearing, the judge looked at him and he said, I need you guys to turn yourself into the county jail by 8 a.m. tomorrow morning. So in that case is currently we're working with the local prosecutor's office to keep that moving in the right path. So although my client will probably never get the full amount of money that was stolen from them,
they might get justice.
They might get some justice. That's exactly right. And that's
so
cool.
Do the contractors turn themselves in?
Yeah, they turn themselves in.
And is the DA's office actually pursuing it?
We don't know yet. Okay. We have turned over all of the evidence that we were able to get through our investigation over to the DA's office investigator, and then that investigator is going to send it to the DA's office. We're going to sit down and meet with them, hopefully convince them that the theft in the aggregate across all of these projects, I found evidence of them doing this to the tune of about $800,000 over the past 2 years, Jeez. 2.5 years. So hopefully it's something that the DA's office takes pretty seriously.
Yeah. Well, thank you for bringing a little bit of justice to our small county here in Jackson.
That's what we do.
Do you think there's anything else that a business owner needs to know before getting into construction?
It's an overwhelming process, but managed correctly with the people who have the expertise and do this on a daily basis. It can be seamless, and it can be one of the most rewarding processes you've ever been through.
Yeah.
But the key is management of this, and that starts with your due diligence into the contractor that you're eventually going to hire, and your contract terms. And having that process managed is well worth the additional expense on the upfront to avoid what could be catastrophic liabilities and expenses if something goes wrong. And then another thing I want to also talk about, because this lien law is a very scary thing, right? Because there's so many moving parts. In the end, there are ways to guard against a lien being filed on your property. But if something goes wrong and everyone does what they're supposed to with preserving their lien rights, you could very well end up in a position where you have a lien on your property. one thing that would make your construction project a little bit more expensive, but would protect you against these things, is requiring a performance and payment bond from your general contractor. Now, you are going to absorb the cost on this, right? Like, this is something the owner is going to pay for. But what performance and payment bonds do, right, is a reputable contractor will have the bonding capacity to be able to go to a surety. And the surety is going to issue a bond on these projects, generally for the amount that the construction contract is worth. So say you have $1 million construction contract, right? The surety then issues 2 bonds, a performance bond and a payment bond, right? What the performance bond does is it guarantees the owner that if the general contractor fails to prosecute the work as they're required to under the contract, the surety says, I will step in and I will finish the project if something goes wrong. I will hire someone else to do the project at the price that you negotiated for. And if your general contractor doesn't do it, I, as the surety, will get in and I will complete the work, right? That's your performance bond.
So it's like insurance, right?
A little bit, a little bit, but only there are some nuances that we probably don't have the time to go in for. This is a project-specific bond, and that performance bond protects the owner to ensure with an E and not I, to ensure that the owner is going to ultimately get the work done that they contracted for. The payment bond goes the other way, right? So the performance bond goes to the owner. The payment bond goes downstream to the subcontractors, vendors, and suppliers. So that payment bond is the surety telling all of the suppliers, all of the subcontractors, all of the vendors, if you are not paid for work properly performed under this contract and the contractor has been paid and they failed to pay you, you can, instead of filing a lien against the property to try to foreclose on the property and recover the payments that you're owed, now you can come to us as the surety, show us where you haven't been paid, show us where the work you've done has been completed and was satisfactory and done in strict accordance with the plans and specifications in your contract. And if you haven't been paid, we've got the cash to pay you. Nice. And that takes the risk off of the owner. Again, the owner is going to pay for this up front. You know, that price of that bond is going to be tacked on to your contract price. But it's a heck of a lot better than getting surprised with several $100,000 worth of liens on a project.
Yeah.
So, and it also tells you that you've got a strong and reputable contractor, right? If they're able to get the performance and payment bonds, they've got the credit history, the work history, the assets to be able to get these bonds, then you've got someone who's serious about their business.
And I imagine the cost of these bonds is going to be dependent on how large the project is.
That's exactly right. Yeah, all the cost is typically based off of the project price. That's exactly.
Gotcha. So for a smaller project, it may make sense financially for the property owner to require these bonds.
Yeah, it very well may. It very well makes sense. And it certainly makes sense on the really big projects where if something goes wrong, you could be out of business and you're just trying to expand your business and make more money. So. Sure. Yeah.
Awesome. Anything else you want to tell the world about construction law?
It's an exciting area. It's very nuanced area. It takes a very in-depth understanding of the construction process itself, as well as the contracts. So before you get in, make sure you don't get in over your head. And I'd say hire a specialist.
Phil, how can people find you if they want to work with you?
Sure. So I am Philip Parham, last name Parham. I work at Guilmette Henderson, LLC in Midtown Atlanta. I do work all over the state of Georgia. I also do some limited work in other states as well, depending on the circumstances. But you can get in touch with me at Philip, Phillip, at Guilmette Henderson. That's GUILMETTE Henderson.com. So Philip at GuilmetteHenderson.com is my email address.
Awesome.
Yeah, and I wish Tim Guilmette didn't have such a complicated spelling.
Such a fancy French last name.
Such a fancy last name, that Tim.
He's a fancy guy.
He is
we'll
a fancy guy.
We'll have to have him on next time.
He is a fancy guy.
Well, Phil Parham III, I appreciate it. Thank you for the time. I think that was excellent advice for any business owner that's looking to get into construction or, taking a plunge and build their own building.
Yeah, it's good seeing you.
Yeah, good to see you too.
And it's awesome being out here in Jefferson. This is a different world than down there.
Sure is. I love it.
Yeah, I can see why.
I'll have to get you out.
I can see why. Do it.
Thanks, man.
I appreciate you, brother.
Good job.
Talk to you soon.
Yeah.